So, Verba, Juris, Bar Review Notes by David Robert Aquino. Labor Law and Social Legislation. First Sunday afternoon. Page 261. 4:55 AM, May 26, 2022. Labor law. Man who worked once a despot and a slave, a dupe and a deceiver became. A traveler from the cradle to the grave, in the dim of light of this immortal day. Percy by Shelley. Fundamental Principles. Legal Basis, 1987 Constitution. Section 3. The state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. Shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. Right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be required by law. The state shall promote the principle of shared responsibility between the workers and employers, and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the right to labor, to its just share in the fruits of production, and the right of enterprises to reasonable returns to investments and to expansion and growth. The constitutional commitment to the policy of social justice cannot be understood to mean that every labor dispute shall automatically be decided in favor of labor. As an exception, case law allow the grant of separation pay or financial assistance to a legally dismissed employee as a measure of social justice or on grounds of equity. As a measure of social justice, the award of separation pay or financial assistance has been upheld in some cases even if there is no finding of illegal dismissal. Civil Code. As an exception, case law allows the grant of separation pay or financial assistance to a legally dismissed employee as a measure of social justice on grounds of equity. If the social security system cannot guarantee the security of those who work for it, it is doubtful that it can even discharge its directive to promote the social security of its members in line with the fundamental mandate to promote social justice and to ensure the well-being and economic security of the Filipino people as a vital government entity charged with ensuring social security, which will lead in setting the example by treating everyone with justice and fairness. If it cannot guarantee the security of those who work for it, it is doubtful that it can even discharge its directive to promote the social security of its members in line with the fundamental mandate to promote social justice and to ensure the well-being and economic security of the Filipino people. In this jurisdiction, the long-honored legal truism of equal pay for equal work has been impregnably institutionalized. Persons who work with substantially equal or not the disputants stand in the proximate relations of employer and employee. As a measure of social justice, the award of separation pay or financial assistance has been upheld in some cases, even if there is no finding of illegal dismissal. Labor Code. Our laws on labor, foremost, which is the Labor Code, are pieces of social legislation. They have been adopted pursuant to the constitutional recognition of labor as a primary social economic force. And to the Constitution mandates for the state to protect the rights of workers and promote their welfare. And the Congress to give the highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity and state, to assure the right of workers to security of tenure. It is a time-honored rule that in controversies between a laborer and his master, doubts reasonably arising from the evidence or in the interpretation of agreements in writing should be resolved in the former's favor. State policy towards labor. It is well settled that employers have the prerogative to impose standards on the work quantity and equality of their employees and provide measures to ensure compliance. Since the employment contracts of overseas Filipino workers are perfected in the Philippines and following the principle of lex loci contractus, the law, the place where the contract is made. These contracts are governed by our laws, primarily the Labor Code of the Philippines and its implementing rules and regulations. Even if a Filipino is employed abroad, he or she is entitled to security of tenure among other constitutional rights. Unless the employment contract of an overseas Filipino worker is processed through the Philippine Overseas Employment Administration, the same does not bind the concerned OFW because the contract is not reviewed by the POEA. Certainly, the state has no means of determining the suitability of foreign laws to all overseas workers. It is a time-honored rule that in controversies between a laborer and his master, doubts reasonably arising from the evidence or in the interpretation of agreements and writings should be resolved in the former's favor. It is settled that a client may enter into a compromise agreement with adverse party to terminate the litigation before a judgment is rendered therein. And if the compromise agreement is found to be in order and not contrary to law, morals, good customs, and public policy, its judicial approval is in order. Security of tenure. In exceptional cases, the Supreme Court has granted separation pay to a legally dismissed employee as an act of social justice or on equitable grounds. In both instances, it is required that the dismissal one was not feel serious misconduct, and two did not reflect on the moral character of the employee. Our laws on labor, foremost of which is the Labor Code, are pieces of social legislation. They have been adopted pursuant to the constitutional recognition of labor as a primary social economic force and to the constitutional mandates for the state to protect the rights of workers and promote their welfare, and for Congress to give highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity and state, to assure the right of workers to secure of tenure. It is in consonance with the guarantee of security of tenure in the Constitution and elaborated in the Labor Code. A dismissed employee is not required to prove he is innocent of the charges leveled against him by his employer. The determination of the existence and sufficiency of a just cause must be exercised with fairness and in good faith, and after observing due process. Social justice, Section 1. Congress shall give highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequities by equitably diffusing wealth and political power for the common good. To this end, the state shall regulate the acquisition, ownership, use, and disposition of property and its increments. Section 2. The promotion of social justice shall include commitment to create economic opportunities based on freedom of initiative and self-reliance. The Constitution is committed to the policy of social justice and the protection of the working class. Does not necessarily follow that every labor dispute will be automatically decided in favor of labor. Although the Constitution is committed to the policy of social justice and the protection of the working class, it does not necessarily follow that every labor dispute will be automatically decided in favor of labor. The management also has its own rights. Our present Constitution has gone further in guaranteeing vital social and economic rights to marginalized groups of society, including labor. Under the policy of social justice, the law bends over backward to accommodate the interests of the working class on the humane justification that those with less privilege in life should have more in law, and the obligation to afford protection to labor is incumbent not only on the legislative and executive branches but also on the judiciary to translate this pledge into a living reality. Social justice calls for the humanization of laws and the equalization of social and economic forces by the state so that justice in its rational and objectively secular conception may at least be approximated. Equal work opportunities. Section 3. The state shall afford full protection to labor, local and overseas, organize and unorganized, and promote full employment and equality of employment opportunities for all. Right to self-organization and collective bargaining. The right to form a union or association or to self-organization comprehends two notions to it: the liberty or freedom that is the absence of restraint, which guarantees that the employee may act for himself without being prevented by law, and the power by virtue of which an employee may, as he pleases, join or refrain from joining an association. In view of the referred right of every worker to self-organization, the law expressly allows and encourages the formation of labor organizations. A labor organization is defined as any union or association or employees which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. A labor organization has two broad rights: to bargain collectively and to deal with the employer concerning terms and conditions of employment. To bargain collectively is a right given to a union once it registers itself with the dole. Dealing with the employer, on the other hand, is a generic description or of interaction between employer. On the other hand, is a generic description of interaction between and employees. Employees concerning grievances, wages, work hours, and other terms and conditions of employment, even if the employees group is not registered with the dole. Construction in favor of labor. It is a time-honored rule that in controversies between a laborer and his master, doubts reasonably arising from the evidence or the interpretation of agreements and writings should be resolved in the former's favor. Finally, the new labor code itself commands that all doubts on the implementation and interpretation of this code, including its implementing rules and regulations, shall be resolved in favor of labor. This echoes Article 1702 of the Civil Code, of the Philippines, which provides that in case of doubt, all labor legislations and all labor contracts shall be construed in favor of safety and decent living for the laborer. The school of thought that resists the expansion of the social rights of employees and workers is essentially capitalistic, conservative, reactionary, and selfish. The invocation of the due process clause to challenge the validity of social and labor legislation as violative of the freedom of contract and undue deprivation of property had long been discarded in America since 1937 case of West Coast Hotel versus Parish, affirming the validity of minimum wage laws in our country. Such a view was repudiated after the 1924 case of People versus Pomar. Thereafter, other legislations followed and survived the constitutional test, such as our own minimum wage law, the 8-hour labor law, the various amendments to the Workmen's Compensation Law, and Employers' Liability Act, law on maternity leave with pay, and laws for the protection of women and minors employed in dangerous industries and occupations. Such statutes were held not to trench upon the Constitution, even in the states of the American Union whose constitutions do not expressly guarantee social justice specifically in favor of the working class, as heretofore stated. Burden of proof and quantum of evidence, they are means for effecting social justice. Example, the humanization of laws and the equalization of social and economic forces by the state. Social justice in the rational and objectively secular conception may at least be approximated. Constitutional law, Article 13, Section 3 of the 1987 Constitution, guarantees the right of workers to security of tenure. Article 13, Section 3 of the 1987 Constitution guarantees the right of workers to security of tenure. One's employment, profession, trade, or calling is a property right, of which a worker may be deprived only upon compliance with due process requirements. It is the policy of the state to assure the right of workers to security of tenure. The guarantee is an act of social justice. When a person has no property, his job may possibly be his only possession or means of livelihood. Therefore, he should be protected against any arbitrary deprivation of his job. Article 280 of the Labor Code has construed executive tenure as meaning that the employer shall not terminate the services of an employee except for a just cause or when authorized by the court. Just cause. The Supreme Court has the authority to sift through the factual findings of both the Court of Appeals and the National Labor Commission in the event of their conflict. The Supreme Court does not re-examine the factual findings of the NLRC, nor does it substitute its own judgment where there is a finding of fact of labor tribunals are generally conclusive on the Supreme Court. Recruitment and placement. Definition of recruitment and placement. Article 13 of the Labor Code defines recruitment and placement to be any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, or procuring workers and includes referrals, contract services, promising, or advertising for employment, locally or abroad, whether for profit or not, provided that any person or entity which in any manner offers or promises for a fee employment to two or more persons shall be deemed engaged in recruitment and placement. Recruitment and placement is any act of canvassing, enlisting, contracting, transporting, and placement. includes the act of referral or the act of passing along or forwarding to an applicant for employment after an initial interview of a selected applicant for employment to a selected employer, placement officer, or bureau. Regulation of recruitment and placement activities. While Section 2, Republic Act RA number 8042 states that the state does not promote overseas employment as a means to sustain economic growth, the state recognizes the vital role of overseas Filipino workers in the nation's economy and development. Aware that overseas workers are vulnerable to exploitation, the state sought to protect the interests and well-being of these workers with creation of a specialized bodies such as the POEA under the direct supervision of the DOLE Secretary, Philippine Overseas Employment Administration. One of the rules of the POEA is the regulation and adjudication of private sector participation in the recruitment and placement of overseas workers. Article 25 of the Labor Code as amended reads Article 25. Private sector participation in the recruitment and placement of workers pursuant to national development objectives and in order to harness and maximize the use of private sector resources and initiative in the development and implementation of a comprehensive employment program. Private employment sector shall participate in the recruitment and placement of workers locally and overseas under such guidelines, rules, and regulations as may be issued by the Secretary of Labor. This is echoed in Article 35 of the Labor Code as amended in Section 23, RA 8042 as amended by RA 9422, where the legislature empowered the DOLE and POEA to regulate sector participation in the recruitment and overseas placement of workers, to wit Article 35, suspension and or cancellation of licensing authority. The Secretary of Labor shall have the power to suspend or cancel any license or authority to recruit employees for overseas employment for violation of rules and regulations issued by the Secretary of Labor, the Overseas Employment Development Board, ADB, and the National Seamen Board, or for violation of the board provision, this and other applicable laws, general orders, and letters of instruction. Regulatory and visitorial powers of the Department of Labor and Employment Secretary. We sustain the jurisdiction of the Respondent Secretary. As the Respondent correctly pointed out, this Court's ruling in Servando that the visitorial power of the Secretary of Labor to order and enforce compliance with labor standard laws cannot be exercised where the individual claim exceeds 5,000 pesos can no longer be applied in view of the enactment of RA number 7730 amending Article 128 of the Labor Code. Article 128B, notwithstanding the provisions of Articles 129 to 117 of this Code to the contrary, in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or duly authorized representatives shall have the power to issue compliance orders to give effect to the labor standards provisions of the Code and other labor legislation based on the findings of the labor and employment and enforcement officers or industrial safety engineers made in the course of inspection. The Secretary or his duly authorized representative shall issue deeds of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor, employment, and enforcement officer raises issues supported by documentary proofs which were not considered in the course of inspection. An order issued by the duly authorized representative of the Secretary of Labor and Employment, unless this article may be appealed to the latter. In case said order involves a monetary award, an appeal by the employer may be perfected only upon the posting of a cash or surety bond issued by a reputable bonding company duly accredited by the Secretary of Labor and Employment in the amount equivalent to the monetary award in the order appealed from. Ban on direct hiring. No employer may hire a Filipino worker for overseas employment except through the boards and entities authorized by the Secretary of Labor. Direct hiring by members of the diplomatic corps, international organizations, and such other employers as may be allowed by the Secretary of Labor is exempted from discrimination. Public Act Number 8042 is silent in this respect. The boards referred to in this article pertain to the DEFA, OADB, and the NSB with the changes introduced by Executive Order Number 797 as amended by EA. Now refers to the POEA. This article should be read in relation to sections 29 and 30 of the Public Act Number 8042, which provides for the formulation of the deregulation plan of recruitment activities functions of the POEA. Except as provided in Chapter 2 of this title, no person or entity other than public employment officers shall engage in the recruitment and placement of workers. Section 14, subparagraph B.1, suspension or cancellation of license or authority. Section 22 of the Public Act Number 8042, as amended, is hereby amended to read as follows. B.1, Philippine Overseas Employment Administration. The administration shall regulate private sector participation in the recruitment and overseas placement of workers by setting up a licensing and registration system. It shall also formulate and implement in coordination with appropriate entities concerned, when necessary, a system for promoting and monitoring the overseas employment of Filipino workers, taking into consideration their welfare and the domestic manpower requirements. It shall be responsible for the regulation and management of overseas employment from the pre-employment stage, securing the best possible employment terms and conditions for overseas Filipino workers, taking into consideration the needs of vulnerable sectors and the peculiarities of sea-based and land-based workers. In appropriate cases, the administration shall allow the lifting or suspension of any recruitment manning agencies upon the payment of fine of 50,000 pesos for every month of suspension. Prohibited practices. For purposes of this act, legal recruitment shall mean any act of canvassing, enlisting, contracting, transporting, utilizing, whether for profit or not, undertaken by an unlicensed authority contemplated under Article 30F, referred to as amended, otherwise known as the Verba. Such non-licensed or non-holder who, in any manner, offers or promises for a fee to two or more persons shall be deemed so engaged. Include the following acts, whether permitted by any person. So it's non-holder licensee or holder authority. To charge or accept directly or indirectly any amount greater than the specified in the schedule of allowable fees prescribed by the Secretary of Labor and Employment, or to pay a worker paid any amount greater than that actually received by him as a loan or advance to furnish or publish any false notice or information or document in relation to recruitment or employment, to give any false testimony, false notice, testimony, information or document, commit any act of misrepresentation of the purposes authority under the Labor Code to induce or attempt to induce a worker already employed to quit his employment. Another, unless the transfer is designed to limit the oppressive terms and conditions of employment. E. To influence or attempt to influence any person or entity not to employ any worker who has not applied for employment through his agency. F. To engage in the recruitment activities shall from the public health or morality or the dignity of the Republic or the Philippines. G. To obstruct or attempt to obstruct inspection by the authority by his duly authorized representative. H. To fail to submit reports on the status of employment, placement, vacancies, remittances of exchange, earnings, separations from jobs, departures, and such other matters of information as may be required by the Secretary of Labor and Employment. I. To substitute or alter to the prejudice of the worker private contracts approved and verified by the Department of Labor and employment from the time of actual signing thereof by the parties up to, including the period of the expiration of the same without the approval of the Department of Labor and Employment. J. For an officer or agent of a recruitment placement agency to become an officer or member of the board of any corporation engaged in travel agency or to be engaged directly or indirectly in the management of a travel agency. K. To withhold ordinary travel documents from applicant workers before departure for monetary or financial considerations other than those authorized under the Labor Code and its implementing rules and regulations. L. Failure to actually deploy without valid reasons or is determined by the Department of Labor and Employment. And M. Failure to reimburse expenses incurred by the workers in connection with this documentation and processing for purposes of deployment in cases where the deployment does not actually take place without the workers' fault. Legal recruitment when committed by a syndicate or in large scale shall be considered as offense involving economic sabotage. Legal recruitment is deemed committed by a syndicate carried out by a group of 3 or more persons conspiring or confederating with one another. It is deemed committed in large scale if committed against 3 or more persons individually or as a group. Persons criminally liable for the above offenses are the principals, accomplices, and accessories. In case of juridical persons, the officers having control, management, or direction of their business shall be liable. Legal recruitment. There is illegal recruitment when one who does not possess the necessary authority or license gives the impression of having the ability to send a worker abroad, where the offense is committed against which a higher penalty under Article 39 of the Labor Code. Recruitment becomes illegal when undertaken by non-licensee or non-holders of authority. Elements. It is necessary that the prosecution prove the concurrence of the following elements. The offender undertakes any of the activities within the meaning, recruitment, and placement under Article 13b of the Labor Code or any of the prohibited practices enumerated under Article 34 of the Labor Code. And 2. The offender engaged in recruitment and placement of workers. In the case of illegal recruitment in large scale, a third element is added that the offender commits any acts of recruitment and placement against 3 or more persons individually or as a group. For illegal recruitment in large scale to prosper, the prosecution has to prove 3 essential elements. Accused undertook a recruitment activity under Article 13b or any prohibited practice under Article 34 of the Labor Code. Accused did not have the license or the authority to lawfully engage in the recruitment and placement of workers. And 3. The accused committed such illegal activity against 3 or more persons individually or a group. To constitute illegal recruitment in large scale, 3 elements must concur. The offender has no valid license or authority required by law to enable him to lawfully engage in recruitment and placement of workers. The offender undertakes any of the activities within the meaning of recruitment and placement under Article 13b of the Labor Code, 320, or any of the prohibited practices under Article 34 of the said code. And the offender committed the same against 3 or more persons individually or as a group. Legal recruitment is committed by persons who, without authority from the government, give the impression that they have the power to send workers abroad for employment purposes. Types. Prosecution was able to establish that the parent was engaged in illegal recruitment in large scale. It was proved that the parent was not licensed or non-holder of authority to recruit workers for deployment abroad. She offered or promised employment abroad to private complainants. She received monies from private complainants purportedly as placement of processing fees. That private complainants were not actually deployed to Brunei. That despite demands, appellant failed to reimburse or refund to private complainants their monies, and that appellant committed these prohibited acts against 3 or more persons, individually or as a group. Illegal recruitment as distinguished from estafa We point out that conviction under the Labor Code for illegal recruitment does not preclude punishment under the revised penal code for the crime of estafa. We are convinced that the prosecution proved beyond reasonable doubt that appellant violated Article 2152A of the revised penal code as amended, which provides that estafa is committed by any person who defrauds another by using a fictitious name or by falsely pretending to possess power, influence, qualifications, property, credit, agency, business, by imaginary transactions or similar forms of deceit executed prior to or simultaneous with the fraud. Liability of local recruitment agency and foreign employer. Solidary liability in labor cases. Corporate directors and officers are solidarily liable with the corporation for the termination of employment of employees only if such is done with malice or in bad faith. Section 10 of Migrant Workers and Overseas Filipino Act of 1995 provides that the foreign employer and the local employment agency are jointly and severally liable for money claims, including claims arising out of an employer-employee relationship and or damages. In the case of overseas employment, either the local agency or the foreign employer may be sued for all claims arising from the foreign employer's labor law violations. To hold a director or officer personally liable for corporate obligations, two requisites must occur. Complaint must allege in the complaint that the director or officer was guilty of gross negligence or bad faith, and two, complainant must clearly and convincingly prove such unlawful acts, negligence, or bad faith. The existence of interlocking directors, corporate officers, and shareholders is not enough justification to pierce the veil of corporate fiction in the absence of fraud or other public policy considerations. Theory of imputed knowledge. In Sonnes, the court ruled that the theory of imputed knowledge ascribed the knowledge of the agent to the principal. Theory of imputed knowledge. Not the other way around. The knowledge of the principal foreign employer could not therefore be imputed to its agent, as there was no substantial proof that Sonnes knew of and consented to be bound under the 2-year employment contract extension. It could not be said to be privy thereto. As such, it and its owner were not held solidarily liable for any of the complainant's claims arising from the 2-year employment extension. Termination of contract of migrant worker. In case of termination of migrant worker, of overseas employment without just, valid, or authorized cause as defined by law or contract, or any unauthorized deductions from migrant worker's salary, the worker shall be entitled to the full reimbursement of his placement fee and the deductions made with interest at 12% per annum, plus his salaries for the unexpired portion of his employment contract for 3 months for every year of the unexpired term, whichever is less. Employment of non-resident aliens. Every employer or any person who pays or controls the payment of compensation to an employee, whether resident, citizen, or alien. The resident citizen or non-resident alien engaged in trade or business in the Philippines must withhold from such compensation paid an amount computed in accordance with these regulations. Proof of loss. In the case of a non-resident alien individual or foreign corporation, the losses deductible are those actually sustained during the year incurred in business or trade conducted within the Philippines, and losses actually sustained during the year in transactions entered into for profit in the Philippines, although not connected with their business or trade, when such losses are not compensated by insurance or otherwise. The Secretary of Finance, upon recommendation of the Commissioner of Internal Revenue, is hereby authorized to promulgate rules and regulations prescribing, among other things, the time and manner by which the taxpayer shall submit a declaration of loss sustained from casualty or from robbery, theft, or embezzlement during the taxable year, provided that the time to be so prescribed in the regulations shall not be less than 30 days nor more than 90 days from the date of the occurrence of the casualty or robbery, theft, or embezzlement giving rise to the loss. ACOA's insistence labor standards, conditions of employment. ACOA's insistence that industrial peace is not the determining factor under the principles of the SSL in fixing the compensation of DVP's employees is correct. The grant of a wider latitude of DVPs, BOD in fixing remunerations and emoluments does not include an obligation of the principle that employees in the civil service are not use the same weapons employed by the workers in the private sector to secure concessions from the employees, while employees of chartered GFIs, government GFIs, enjoy the constitutional right to bargain collectively. They may only do so for non-economic benefits and those not fixed by law, and may not resort to acts amounting to work stoppages or interruptions. There is no other way to view the GFPA other. Then a monetary benefit collectively wronged by DVP's employees under threat of disruption of banks' smooth operations. We held in Dulce M. Abanilla versus Commission on Audit, reiterating alliance of government workers versus Minister of Labor and Employment, subject to the minimum requirements of wage laws and other labor and welfare legislation, the terms and conditions of employment the unionized private sector is settled through the process of collective bargaining. In government employment, however, it is legislature and, where properly given delegated power, the administrative heads of government which fix the terms of conditions of employment, and this is effected through statutes or administrative circulars, rules and regulations, not through collective bargaining agreements. CBA. Also, we affirm the awards except those with the guaranteed overtime pay and legal holiday pay under Article Act Number 8042. The unjustly terminated employee is entitled to the full reimbursement of his placement fee with interest at 12% per annum, plus his salaries for the unexpired portion of his employment contract. We further allow the payment of vacation leave pay and sick leave pay because the employment contract stipulated 12 days vacation leave with pay and 7 days sick leave with pay, and that will be taken after 1 year. Compensable time. Such incontrovertible facts calls for the application of the rebuttable presumption that said illnesses arose out of or were at least aggravated by the nature of petitioner's employment, hence compensable. Consequently, the employer assumes by force of this presumption that the burden of establishing the contrary by substantial evidence, as there was no evidence presented by the employer to rebut the presumption. There can therefore be no justification for a respondent commission to go out of its way to absolve the petitioner's employer, as the presumption of compensability becomes thereby inclusive. Number of hours of work. We affirm the awards except those for the guaranteed overtime pay and legal holiday pay under RA 8042. The unjustly terminated employee is entitled to the full reimbursement of his placement pay with interest at 12% per annum, plus his salaries for the unexpired portion of his employment contract. We further allow the payment of vacation leave pay and sick leave pay because the employment contract stipulated 12 days vacation leave with pay and 7 days sick leave with pay that could be taken after 1 year. Night shift differential. Those working between 10 o'clock in the evening and 6 o'clock in the morning are required to be paid a night shift differential based on their regular wage. Holiday premium pay is mandated whether one works on regular holidays or on one's scheduled rest day and special holidays. All these cases, additional compensation is mandated and computed based on the employee's regular wage. Overtime work. Overtime is defined as work performed beyond 8 hours in a workday. A workday is also defined as a 24 hours period from the start of work. So if an employee works from 8 a.m. to 4 p.m. and then from 12 a.m. to 8 a.m., even though there is an 8-hour gap in between, it is still considered a single work day. Therefore, overtime premium shall apply. According to Article 87 of the Labor Code of the Philippines, there are two different overtime rates. The overtime rate for a normal working day in the Philippines is 25% plus the employee's regular wage. However, if overtime is performed on a rest day or holiday, the overtime wage shall be increased to 30% plus employee's regular wage. Burden of providing entitlement to overtime pay rests on the employee because the benefit is not incurred in the normal course of business. Compressed work week, DO number, summer break. Compressed work week, DO number 21, sanctions the overtime pay in consideration of the benefits Save the energy. Efficiency. Favor the scheme considering that it would mean savings on the increasing cost. Maintenance staff expenses on the weekends for an additional 52 days. The employer's additional family responsibilities. Some matters and other days of the week. Certain inconveniences that are normal incidents. Just commuting to and from workplace. Spend exposure to dust and motor vehicle fumes. Thus, under this scheme, the general observed work weeks. 6 days is shortened to 5 days, prolonging the hours from Monday to Friday without overtime premium compensation. It's weekdays in exchange for the benefits above cited that will apply to the employees. Building overtime. Built-in overtime on priced work week. So regulations for posting awarded him that amount as overtime pay they declared for a 10-hour working day because it was contrary to Section 82 of the Labor Code for merely 8-hour labor work. Any employee should not exceed 8 days. Section 87 of the same code which provides that work. Petition that it contains an aspect. Managerial employees are not entitled. And compensable on the alleged alcoholism. Something is controlling reset. Agreement of payment. The prohibition of this game is distortion. Related to the development of the disease. Distortion. Must be instrument. Association properly necessary to effectuate the purpose of this title. should investigate this time. So we will stop on wages. Next topic is on leaves.